I would like to welcome all the participants of the International Seminary on the International Law Response to Weapons of Mass Migration. The seminary co-organized by Hungarian Center for Fundamental Rights, the Italian Nazione Futura, and the Polish Ordo Iuris Institute for Legal Culture as members of the Alliance for the Common Good. I would like to introduce the participants of the seminary. István Kovács, on my left, a lawyer, a strategic director of Hungarian Center for Fundamental Rights. He specializes in European law, the constitutional rules of the European Union, formerly a scholarship holder of the European Parliament and the United States government, author, co-author of legal and political articles, studies, and books. During Hungarian migrant crisis 5-6 years ago, one of the most important participants of legal and political debate on migrant rights and state responsibility to provide security to its citizens. We also are connected with Margherita Saltini from Nazione Futura, an Italian political cultural think tank. She's an expert on international relations and currently a Secretary General of Democratic Youth Community of Europe, an international umbrella organization of the youth wings of Christian, democratic, conservative, and like-minded parties of Europe. She collaborates with the Italian Parliament on foreign affairs. Formerly, she held the position of communication official of the International Labour Organization. Weronika Przebierała, a director of International Law Center of Ordo Iuris Institute, will start the second part of today's conference. And then Professor Wojciech Szewko, a PhD holder and expert of international relations and Middle East from National Center for Strategic Studies, an independent geopolitical studies think tank. He was an advisor to the Prime Minister of Poland and the head of the Office of Minister, and also served as Deputy Minister of Science in Poland. We are also already connected with Piotr Wymysłowski, advocate and specialist at Department of Migrant Rights and National Minorities at the Ombudsman Office, Poland. In the last part of today's seminary, the comments section will be started with the position and commentary from Bartomy Vroblevsky. Dr. Bartomy Vroblevsky is a member of the parliament in Poland. In 2009, he obtained his doctor's degree in law in his alma mater, Adam Mickiewicz University in Poznań. His academic specialization is constitutional law, European law, and human rights. Assistant professor at SWPS University. And this year, Dr. Vroblevsky was one of the candidate of the ruling coalition in Poland for the position of the Polish ombudsman. We will start with short introduction to the situation, the presentation of the current situation on the Polish-Belarusian border. At the second stage of our seminary, we will go to the experiences of European countries in dealing with the legal and political aspects of the migration crisis. And in this second part, I will ask István Kovács and Ms. Margherita Saltini to present their experiences from the Italian and Hungarian point of view, as we are experiencing now what was already experienced by our partners. In this crucial third part, we will focus on legal options for Poland as a state party to the 1951 Geneva Convention relating to the status of refugees in view of the current political and humanitarian situation. And in this crucial third part of today's seminary, Weronika Przebierała will start with the short presentation of our analysis, and then Mr. Wojciech Szewko and Piotr Wymysłowski will follow with their interventions. The third last part of today's seminary, the commentary section, as I mentioned before, will be started by Dr. Bartomy Vroblevsky, and then all of the participants will follow with their comments to the international law response to weapons of mass migration. As a short introduction, I would like to remind that in the end of May 2021, President of Belarus, Alexander Lukashenko, announced that Belarus refuses to protect Europe from illegal migration, drug trafficking, and smuggling, because, as he said, there is no money and no strength to do so due to the European sanctions. Since then, Belarus is actively involved in organizing an increased migration wave and is helping migrants to cross its territory to the border with Poland. The state travel agency Centr Kurort is involved in the migration movement. Tourist visas are being issued to willing migrants on massive scale. And in recent months, there has been a significant increase in air traffic between the countries of origin of migrants, mostly Middle East, and Minsk. In the beginning of this migrant crisis, a spokesman for the European Commission stressed that, I quote, "We firmly reject attempts to instrumentalize people for political ends. We cannot accept any attempt to incite or allow illegal migration to the European Union via third countries." And then European Union Commissioner for Home Affairs, Ylva Johansson, stated that, I quote, "The area on the border of Poland and Belarus is not a migrant issue. It is part of Lukashenko's aggression against Poland, Lithuania, and Latvia, with the aim of destabilizing the European Union." And she pointed out that the Lukashenko regime uses migrants instrumentally to exert political pressure and support them in crossing the Lithuanian border. As we already see, the situation now in 2021 is absolutely different than the situation that was experienced by Italy or Hungary 5 or 6 years ago. During a recent European Parliament debate on border crisis, both the European Commission and numerous members of the European Parliament indicated that today we are not dealing with migration crisis, but with a planned attack on the external border of the European Union. It has been reportedly pointed out that we cannot speak of refugees, but of migrants who came to Belarus in order to illegally cross the border with the Union. It was also emphasized that the circumstances require a strong response. Hence the sanctions that have already been imposed and the others that are being adopted, including those against carriers who, knowingly or not, are involved in smuggling people and trying to destabilize the EU. Many deputies in the European Parliament during this debate, both from left and right-wing fractions, also directly criticized the actions of the states whose representatives entered into contact and negotiations with Belarus, without taking into account the need for solidarity in the European Union and ignoring the most important states in this conflict, Poland, Lithuania, and Latvia. Those deputies also pointed out that those contacts, mostly held by Germany, were legitimization of Lukashenko's regime, unacceptable in the face of political situation in Belarus since 2020, rigged elections, and finally the current situation on the border. Bogusław Liberadzki, a member of the European Parliament from the Progressive Alliance of Socialists and Democrats, therefore called for, I quote, "an almost demonstrative unity of the European Union." Migrants on the Polish-Belarusian border are under strict control of Belarusian border guards and the State Security Committee of the Republic of Belarus, KGB. The provocative actions taken by Belarusian border guards reveal that the Belarusian regime is trying to provoke as many tragedies at the border as possible, including incidents with the use of weapons. All of this points to the so-called provoked migration, which in the doctrine of international law is defined as manipulation of the migration of population as an operational and strategic means to reach political and military ends. This phenomenon has been studied and described in political science and called weapon of mass migration by Kelly Greenhil in 2010. The procured migration lead directly to humanitarian threats and expose instrumentalized groups of population to a threat. At the same time, the aim of this action is internal and external destabilization of the state falling victim to procured migration. And therefore, the intention of the perpetrator state is to create a threat to international peace and security. The legal aspects can be viewed through the perspective of various legal instruments. I will just name them: the 1951 Geneva Refugee Convention, of course, the European Convention on Human Rights, and numerous acts of European Union, like the Council Directive on minimum standards for giving temporary protection in the event of mass influx of displaced persons, and on measures promoting a balance of efforts between the member states in receiving such persons and bearing the consequences thereof, and the regulation of the European Parliament and the Council on a Union Code on the rules governing the movement of persons across borders, Schengen Borders Code. The last international act, the international treaty that should be mentioned here, as it could be invoked to classify the actions of Belarus as state-organized criminal activity, is United Nations Convention Against Transnational Organized Crime from 2000, and the additional protocol against the smuggling of migrants by land, sea, and air, both ratified by Belarus and prorogating dispute resolution to International Court of Justice. There are already ongoing proceedings in the European Court of Human Rights that should be mentioned here. They apply, the ECHR applies interim measures called on the Polish and Latvian authorities to provide food, water, clothing, adequate medical care, and, if possible, temporary shelter to foreigners camped at the border on the Belarusian side. The application of this measure is without prejudice to any obligations of Belarus under international law concerning the situation of migrants. Moreover, the court made it clear that this measure should not be understood as requiring Poland or Latvia to admit the applicants into their territories. The state bears the burden of proof that it has complied with the provisional measure. However, the ECHR, acting in September in the case against Poland by extending the ordered interim measures and ordering 2 new measures, makes their application each time conditional on the truthfulness of the information provided by the applicant's attorneys and on the actual presence of foreigners in the territory of Poland, as it is challenged and disputed, whether or not they have crossed the border since the beginning of the crisis to the moment of issuing of this order. One can say that people staying on the border are instrumentalized as weapons in hands of forces hostile towards the European Union. And the situation is an act of modern hybrid warfare. What should be the legal reaction of the international society? What should be the reaction of the states parties to this crisis? What should be the reaction of the European Union? And what are the experiences of our partners who have this problem of crisis and mass migration before? This is the first part of today's seminary, and I would ask István Kovács from the Hungarian Center for Fundamental Rights to present his experiences and the Hungarian experiences on this issue.
Thank you, Jerzy. Ladies and gentlemen, as Jerzy just said, the Center for Fundamental Rights was the first Hungarian organization in 2015, in the very early of the year. We put a proposal on the table openly, but it was required for amendment to the that time effective Hungarian regulation on asylum. And it was about how to strengthen the rules in line with the respective European regulation. And ever since then, the Hungarian parliament adopted several amendments to the legal environment, and the European Court of Justice worked in order to to make them withdraw. So it has been a race between Hungary and the European Union in order to keep all the migrants out of the borders. And the situation Poland is facing right now very similar to what we had 6 or 5 years ago. Anyway, I'm honored to speak here today, although I would like to get into details of a very delicate matter. How many pro-migration lawyers do you need to change the word? The answer is rather difficult. Even being small in number, they will apply. They will be happy to offer their assistance because they actually moving their own case forward step by step, letting migrants on domestic soil and stalling the asylum procedure as long as possible before their clients could be expelled. On the other hand, pro-migration judges will be eager to temporarily suspend expulsion cases, while the average Joes are looking after their interest every day in Europe. I am certain that there are genuine refugees who are really in need of help. Fortunately, it is not that hard these days to make the distinction between migrants and refugees because they behave totally in a different manner. Let me walk you through a hypothetical situation, a Hungarian one. There is a village on the Ukrainian side of the Hungarian border. It lays on the left side of the Tisza River with a road connecting it to the rest of Ukraine, which is parallel to the river. The nearest village on the Hungarian side is directly linked to the border, 1.8 kilometers from the village in Ukraine. On a gray, rainy day in March, a flooding river breaks through the dam and the water starts spreading with catastrophic speed. By the time the residents of the village notice, they've been cut off from the road that leads to the neighboring village in Ukraine. They rush off the other direction to Hungary, cross into their western neighbor, and find the first police officer to ask for help. In the meantime, the Ukrainian emergency services already tackled the flooding. Days pass before the authorities can make the village livable once again and find temporary housing for those people who lost their home. All this time, the villagers find shelter in Hungary. And on the, let's say, 18th day of the crisis, the Ukrainian authorities have fully in control the situation, and the villagers return to Ukraine. In the very scenario the mentioned above, the villagers were real refugees fleeing from genuine catastrophe. They did everything correctly in accordance with the applicable regulation. First of all, after having had crossing the border, they made contact with the local authorities, informing them on their situation. The authorities of the host country organized immediate relief. At the end of the story, the disaster was overcome. The villagers returned to their home country. Now, let's assume if they had not done so. And instead of seeking help from the Hungarian authorities, they had decided to march through the country all the way to the Croatian border to turn this opportunity into a lifelong stay in the Croatian seaside. All of a sudden, these people can hardly be considered to be refugees, can they? And you would understand why the Hungarian authorities might be unpleasant with their conduct, or why Croatia might use their admission, not fleeing obliged, to lend a helping hand towards these quasi-refugees. And despite what people contributing the idea of open society would have you believe, international asylum law and Geneva Convention on refugees do make a clear distinction between genuine refugees and those migrants who are trying to take advantage of the system. You may have to look at thoroughly, but the difference is there. Article 2 of the Geneva Convention stresses that every refugee has duties to the country in which he finds himself, which require, in particular, that he conform to its laws and regulations, as well as to measures taken for the maintenance of public order. On one hand, obviously, this means that if you want to be acknowledged, recognized as a refugee, you will have to follow the rules and regulations of the country where you find yourself. And you are absolutely not to cause any inconvenience to the law enforcement or the local citizens. Less obviously, this article contains what we often here referred as the first safe country principle. Let me elaborate on this. Sovereign countries do not allow the crossing of their borders without proper paperwork, not just into the country, but also out of the country. Polish rules and regulations will expect you, or any of you, to have a photo ID on you if you choose to travel to Germany. The Polish police might not check you every time, but you are still required to possess the document. So how a refugee arrives in a safe country when there are proper state authorities that have established a proper legal and regulatory environment is not to be asked, because people have the right to flee calamity. And remember, now we are talking about real refugees here, not people with the intention of abusing the system. But as they are in a country with rules, orders, and security, if they wish to maintain their status as refugees, they must comply with the local requirements. And all the countries in the world will absolutely have the requirement not to cross their borders without proper paperwork. So the refugee must therefore register his status with the local authorities and receive proper documentation before he leaves the country. By undertaking himself to this procedure, he makes a proper application for the asylum. Once they have the required documentation, they are free to travel as they would have been under normal circumstances. Countries, of course, are also free to decide not to grant them visas, which is exactly why pro-migration NGOs are so quick to forget about the implications of the Article 2 of Geneva. Of course, safe countries hit by waves of refugees very often, and this can put enormous pressure on them. There are various methods how they tackle this pressure. Sometimes they encourage the refugees to leave the area of the country as soon as possible, even without any paperwork. It is not rare that they help these people to cross the border illegally into the neighboring countries. This happens too often, but let us note that this attitude leads to consequences that just came into effect. The country in question has broken the international asylum law, and the people, now merely migrants, have failed to live up to the reasonable requirements of the Article 2 of Geneva Convention. Occasionally, irresponsible countries tend to facilitate migration, or not only because of their burdens that accepting real refugees placing on them, but because they want to use massive, uncontrolled migration as a hybrid warfare against their neighboring countries. This is exactly what Belarus just did recently. Offering Minsk financial assistance by the EU would obviously be a huge mistake. In this case, it would just embolden Lukashenko, who hardly needs more encouragement to abuse the system. The solution is the protection of the border at all the cost. The key is the consistency, and the message we signal should be clear for everyone. We, as the frontier states of the Union, will never tolerate to abuse our borders. If the Polish authorities are steadfast in their determination not to let in a single migrant without the proper border procedure, the people will cease to come. And I think this is the real story behind the Hungarian border protection. So last summer, a famous American TV commentator, I'm pretty sure that most of you know him, Mr. Tucker Carlson, visited Hungary. And he said to me that the most amazing thing was how Hungary, which is regarding its GDP, its military capacity, and its population is so small compared to the US, can control its border, while the US, with all the money in the world, with high technology, the strongest military capacity, cannot. And he said that according to his views, the willingness of the Hungarian authorities to determine to defend their borders is the key. So this is the way Poland should follow. Thank you for your attention.
Thank you very much, Istvan, for your presentation, for your statement. And yes, this willingness to protect the borders, to protect the national borders, is also the part of constitutional identity of our countries. And this focus you have presented on the duties of the migrants and the duties on the migrants on their path to the safe haven is also very important for our contemporary problems. I would like to ask Margherita Saltini to present her perspective on the migration crisis and the Italian experience on that in her presentation. The floor is yours.
So, dziękuję bardzo. Thank you for welcoming here. I believe that the experience from Italy is quite representative, even though there was a big shift right now with the Poland-Belarus case. First of all, I would like to remind that the problematics that Italy endured in 2015 are far from over. The migration route to get to the European, Europe and to the European Union are verified. They get through different types of routes. There's the Western African, there's Western Mediterranean. It's very important. The Western Balkan that has 48,000 illegal crossings every year, but the Central Mediterranean is by far the worst. And it affects completely Italy because of its strange geographical structure. So my country is affected both from the Central Mediterranean route and the Western Balkan route, both of them. But Western Central Mediterranean is extremely important. And what is more severe is that it's not solved and it's getting worse. In the last 3 years, the situation has deteriorated so much. There are 6 times more illegal crossing than 3 years ago. In 2019, there were 10,000 illegal crossing coming from the Mediterranean, via Libya and Tunisia mainly. In 2020, 32,000. And now, this year, until yesterday, so the data from the Minister of Internal Affairs of yesterday, 61,000 people crossed the border and arrived in Italian coast parts. And 61,000, it's a very massive number. And if we look at the nationality of people coming, they're very diverse and different than the ones that, for instance, come through the Balkans or are coming to Poland. The nationalities getting to Italy and wanting to join other European countries are mainly Tunisian, Egyptian, Bangladeshi, Iranians and Iraqis and Syrians, which should be the ones that technically are more granted to refugee status, are only 4% and 3%. So it's mainly economic migrants trying to get and reach our borders and get inside the European Union illegally. And this has been deteriorated by 6 times in the last few years. So this creates a massive problem. It's a massive problem on several points of view. But what is more problematic is that, first of all, there's not a real land border. It's a sea border. It's an extremely dangerous sea border. Since 2014, according to IOM, there has been 17,000 deaths or people missing at sea. It's a big graveyard we're finding in our beautiful Mediterranean Sea that is the grave of our civilization as well. And now it's becoming a very, very dangerous route. So by not stopping it, we're actually risking people's lives at the same time. And it's extremely problematic because we have not enough tools to face the problem. Right now, Frontex, for instance, is having a mission. It's called Operation Themis, is under the control of the Ministry of Interior of Italy as well. It's a Frontex or EU united mission, but it checks the border, it controls the border, it search and rescue the migrants that are lost at sea, that are encountering problems. They're registering, but they are not returning migrants. They're not preventing them arriving. They're just facing with the reality.
Ms. Saltini, we can't hear you now.
Can you hear me now?
Would you like to try to reopen the channel or to...
Yeah, let me try that.
For technical reasons, just a few seconds of technical attempt to reconnect with Margherita Saltini from Nazione Futura. I hope that we will be able to. Ms. Saltini?
Can you hear me now?
We hear you from afar somehow, so maybe you would like to.
Even now, because like before I change the microphone settings, so let me try see if they work. Do they work better now? Can you hear me better?
I would like to ask our technical team to try to reconnect the voice connection with Margherita Saltini. And now I would like to pass to the third part of the seminary, the legal options for Poland as a state party to the Geneva Convention relating to the status of refugees in view of the current political and humanitarian situation. As I understand the question to the technical team, we don't have a voice connection with Margherita Saltini now. Oh, it's okay. So
I removed it.
Yes, we can hear you very well. Please continue.
Okay, I can continue. Fantastic, thank you. If you have other problems, I can connect to another tool. And sorry for the disturbance. So yes, we have a big problem with returns as well. Returns are not very feasible, not very possible, even though Frontex is behaving very differently in Greece, for instance, where returns are actually taking place. Whereas in Italy, we dealt lots of agreements with Libya. But still, even though it's Libyan authority in Libyan Sea acting with help also Frontex giving them images and Italy providing them data and images from satellites and drones, even so, the European Rights Commissioner of the Council of Europe condemned this practice. We cannot even help the Libyans without being pointed at by the Council of Europe. Because technically, under the convention, the Geneva Convention, you should not allow returns or refoulement even via third countries. So not only to countries that are dangerous, but also to countries that could bring them to countries that are dangerous again. And this happened to the other border, the border of Slovenia, which is a land border, which is within the EU. There has been cases where Italian government and authorities have been returned, so through the procedure refoulement, migrants to Slovenia. They were coming from the Balkans, so they were not legitimate to stay, so they were returned. An Italian court determined that this was illegal and illegitimate by the government, because this refoulement of migrants were going to Slovenia, which is a very safe country, it's a EU country, but Slovenia was bringing them to Croatia. Croatia was returning them to Bosnia. Bosnia was not deemed by Italian Tribunal of Rome as a place where they had safe conditions of life, the migrants. And so they condemned the national authority, the Minister of Interior Affairs. So we also have to deal not only with international conventions and laws that are very hard to apply in a different context, like a sea border or land border in current times, but we also have to deal with internal justice as well, that is behaving and limiting a lot the government moves. And with that, I would like to remind you that the former Minister of Internal Affairs, Matteo Salvini, is still under trial. He's on a prosecution trial for the Open Arms NGO boat case, where he's accused right now of deprivation of liberty and abuse of authority. He's risking prison for kidnapping, basically, because he stopped a boat of an Spanish NGO called Open Arms for 19 days at sea. And he said he did not grant them the right to land in Italian coasts. And because of that, the Italian judges are prosecuting him for deprivation of liberty. So when we have to consider the migration problem, it's really, really also a judicial problem at various levels, not only international, but also national ones. And the last thing that I want to point out is that the united action that has been the united response of the European Union in the Poland crisis is seen as very positive by Italy, because we've had very different feelings. So this I'm talking more politically probably, but we have had the feeling of being completely forgotten, of having countries that still behave in a different way, like France, that is still returning migrants and stopping everybody. If you try to cross the border, they stop everybody, even on a train, and ask them for documents. And there's been practices, they even came into Italian borders. It was bad. We had tensions with the neighboring EU countries, and we had tensions with the European Union as a whole, because we did not see a united action, and we did not see support from the institutions that was considered enough by the Italian government and also by the Italian people. So when the case that is erupting now and is still ongoing, that shows unity towards Poland, is very, very positive, because it could represent a milestone for the attitude and approach towards migration, to find a common ground, tackling big problematics that affect not only Italy, not only Poland, but the European Union as a whole. So let's find the idea for the future is to take it as a first step, not only to tackle the current situation with Belarus, but also to attack the entire issue of migration that is far from solved in other realities like Italy.
Thank you very much for your presentation and remarks. And yes, what we see now from the Hungarian and Italian point of view is that those guarantees aimed to guarantee refugees a safe haven, the true refugees a safe haven in the first secure country, are used in fact as a threat and cause a threat to the security of different countries. And the reaction to that, the reaction of the European Union that is experienced today in case of Poland-Belarus border, is a new experience for the Union. as before 5 years ago or 6 years ago in the Hungarian case, and in the Italian cases, you felt alone, as you said. And it is 20 years ago when Tony Blair has already foreseen the situation, saying that if we construe the international guarantees for refugees in such a way that in fact we violate the basic principle functions of the states to provide security to its citizens, with time it is the refugees who will pay the price, because it is the refugee guarantees that will deteriorate with time, and state after the state will refuse to follow this kind of broad guarantees for the next waves of migrants. And we have to deal with that, to somehow balance the security of our borders, the security of our citizens, with the basic principle of providing secure stay for true refugees. And this is when we move on to the legal options that we see in the international law for Poland as a state party to 1951 Geneva Convention. In view of the current political and humanitarian situation, what should be done, what could be done in this particular situation when the migration crisis is procured by a neighboring country? It is part of an organized action to provoke an influx of migrants from Middle East with the state entrepreneurs from Belarus, like Centr Kurort and the tourist visas of Belarus into Poland, Latvia, and Lithuania. The first presentation will be presented by Weronika Przebierała, Director of International Law Center of Ordo Juris Institute.
Thank you very much. As Mr. Kwaśniewski has already mentioned, the initiation of migration blackmail by Belarus is already directly related to the abuse of humanitarian law and the human rights system, the norms of which are used as a trap for a country being a victim to purposefully created migration. There is no doubt that the victims of purposefully created migration activities are primarily refugees who are instrumentally used to achieve the goals of the state perpetrator of a migration crisis. In such a situation, the fundamental question is, what are the possibilities of action for states that are victims of purposefully created migration in the light of the norms of international humanitarian law concerning the status of refugees? It should be emphasized that in light of the provisions of international law, initiation migration blackmail in order to force another country or countries to undertake political decisions beneficial to the perpetrator, including, as in the case at the hand, lifting the sanctions, constitute a prohibited intervention, i.e. an international unlawful act. This position is confirmed in the norms of international law, in particular in Article 2 of the Charter of the United Nations, and the prohibition of intervention in the internal affairs of another state, which is a norm of customary international law. The said principle of non-intervention was explained as follows by the International Court of Justice in the case of Nicaragua versus United States. In the light of commonly accepted formulation, this principle prohibits all states or groups of states from intervening directly or indirectly in the internal or external affairs of other states. Prohibited intervention is therefore the one that concerns matters over which each state has the freedom to decide freely under the principle of sovereignty. One of these issues in the choice of a political, economic, social, and cultural system and the formulation of foreign policy. intervention is unlawful when it applies coercive methods to those choices that must remain free. The element of coercion, which defines and even constitutes the very essence of a prohibited intervention, is particularly obvious in the case of forced intervention. The analyzed activities of Belarus constitute a violation of international obligations and are associated with the responsibility of this state on the basis of the norms of customary international law, which constitutes one of the sources of the international law system. The principles of liability were codified in a report by International Law Commission, articles on the international responsibility of states for activities prohibited by international law, adopted by the United Nations General Assembly resolution. The general principle states that every internationally unlawful act of a state gives rise to the international responsibility of that state. An international unlawful act is an act or mission imputable to a state under international law and in breach of that state's international obligation. Importantly, the classification of a state's act as international unlawful is determined by international law, regardless of the qualification of the same act in the light of domestic law of the state. Recognizing an act or mission as a breach of international obligations take place if the Assets Act attributed to a state is inconsistent with the requirements of the international obligation incumbent on it, regardless of its source and nature. The sources of obligations include, first of all, international treaties, international customs, which are binding on the state, or of particular importance in the area of humanitarian law and human rights, may also be the mandatory norms. Under international law, the responsibility of a state committing an international unlawful act includes cessation of the act, making appropriate guarantees of uniqueness if circumstances so requires, making full reparation for the harm caused by the act, covering both materials and moral damage. As pointed out by the International Court of Justice, it is a well-established principle of international law that an injured state is entitled to obtain compensation from a state that has committed an internationally unlawful act for the damage caused by that act. Reparation from damage takes the form of restitution, compensation, or satisfaction. First of all, the perpetrator state is obligated to restore the situation that existed before the act, unless it is impossible or would impose a disproportionate burden resulting from restitution instead of compensation. A particular effect is related to an internationally unlawful act which constitutes a serious breach by the states of the obligation arising from the norm of the mandatory universal international law. In this situation, international law imposes an obligation to respond to the entire international community in order to bring about an end to any serious breach by lawful means, as well as an obligation to refrain from recognizing and lawful the situation created by the serious breach. What is worth emphasizing is that due to the decentralized nature of international law, international liability is based on decentralized system allowing that perpetrator be claimed liable for an international unlawful act by the injured state and in certain circumstances by the international community as a whole and by third parties. In light of the above considerations, it should be noted that the basic claims of countries affected by Belarusian migration blackmail are requesting cessation of purposefully created migration, submitting appropriate assurances and guarantees that the migration blackmail will be ceased, making full reparation for the damage caused by the act, including both materials and moral damage. Particularly important in the context of the discussed problem is the issue of providing a guarantee of non-repeating of migration blackmail. Considering the identified mechanism of purposefully created migration, for Belarus, the relevant guarantees could include, first of all, Belarus' commitment to provide migrants with conditions to start refugee producers in Belarus, as well as strict definition of procedures for controlling the movement of people and rules for deportation. Contemporary doctrine of international law increasingly emphasizes the importance of compensation payable directly to victims of violation of international law, in particular the norms of humanitarian life and human rights. The customary norm concerning compensation for victims of violation of fundamental rights is included in Article 8 of the Universal Declaration of Human Rights, Article 2, Clause 3 of the International Convention on Civil and Political Rights, then included in United Nations General Assembly resolution from December 2006. The United Nations Human Rights Committee pointed out that the legal remedies confirmed in Article 2 of the International Covenant on Civil and Political Rights is open to all persons, including stateless persons, refugees and migrants, whose right to compensation for damages and compensation for the harm suffered as a result of violation of fundamental rights must be guaranteed by national law. The obligation of the state to ensure an effective path for obtaining such legal protection is an international obligation erga omnes. As a consequence, its violation gives rise to responsibility towards the entire international community, which any state may claim against the perpetrator of violations for the benefits of the victims. As it is established, while the abuse of the norms of international law may, in some circumstances, lead to a refusal to apply them by the state becoming a victim, the abuse in the context of purposefully created migration does not allow for the suspension of the application of the norms relating to the status of refugees, so that they are not deprived of their protection under international law. On the other hand, the doctrine indicates that repeated actions of purposefully created migration in effect lead to tightening of asylum and immigration regulation and clear obligations to protect the most vulnerable groups of the population. Therefore, long-term institutional and normative opposition to purposefully created migration is necessary for the consolidation of the system of international humanitarian law and the human rights system. It is indisputable that migration blackmail leads directly to humanitarian threats. At the same time, the aim of this action is internal and external destabilization of states falling victims to prosecuted migrations, and therefore the intention of the perpetrator state is to create a threat to international peace and security. This, in turn, gives legitimacy to the actions of the United Nations Security Council on the basis of Chapter of the United Nations Charter. In this context, it is worth reflecting on the concept of considering the possibility of suspending international obligation arising under the Geneva Convention due to the unlawful intervention by abuse of migration guarantees by invoking an inherent right of self-defense that lies in the scope of the perpetuatory norms of public international law. This right is set forth in Article 51 of the Charter of the United Nations, which its use requiring a condition of proportionality to the act that provoked it. The literature emphasized that means can only be proportionate if they are necessary to achieve legitimate objectives, so much case must be considered individually. Each case might be considered individually. Will then the suspension of the application of the Convention provisions as a means taken under the states' rights of self-defense satisfy the condition of proportionality in the fact of the threat of mass migration? In the context of weapons of mass migration, the validity of the Convention norms becomes a de facto trap and part of the machinery of aggression. These guarantees are a sine qua non condition for the effectiveness of migration blackmail, aimed at creating instability in the country. Thus, the proportionality premise appears to be satisfied in this case. Thank you very much.
Thank you very much for this presentation, for your remarks. And yes, we can see those three options for the victims of Belarusian intervention, unlawful intervention, or even aggression, as the European Union calls it. The first one, we can somehow say that Belarus should pay for the wall, accordingly to the international custom as a source of law, accordingly to the articles on the international responsibility for the internationally unlawful acts. The second, as I understand, is that in fact Poland may grant legal protection to the damages to the migrants who want the damages to be paid by Belarus as a liability for their humanitarian situation. And the third one is the possible suspension of the refugee treaty obligations due to the basic and fundamental right of self-defense when the migration waves are used as a weapon of mass migration. Thank you very much. And the second speaker of this part of our seminary will be Wojciech Szewko. Dr. Szewko, the floor is yours.
Do you hear me? This is the first question.
Yes.
Okay, so
perfect,
because I'm sorry, but I will have some technical difficulties. So at the beginning, I would like to congratulate the organizer of this very important seminary because the topic is very current. However, speaking about this influx of the migrants, we are dealing with a few separate, if I could say, problems, which are unfortunately not directly connected. So we are connecting it by our, if I could say, political opinions, but from the point of view of some kind of chain of the cause, between the cause and the results, there are some gaps. And also, we are discussing here about the Geneva Convention, which is dedicated to refugees. But to decide are those people refugees, they have to ask for the international protection. So from our point of view, now they are the citizens of many countries which are on the Belarusian soil. Publicly, they are declaring that they are migrating because of the economical causes. So it is highly possible that they will not receive legally any grant to stay on the European soil, German soil, or whichever soil they will choose. They are the people who are storming the border. So from our point of view and from the point of view of the international law and the domestic law, not only Polish one, but the Belarusian one. So they are the people just who are trying to illegally cross the border. So this is the first part. So from our point of view, they are the criminals who are trying to illegally cross the border. And are they refugees or not? So we will decide if they will ask for international protection in Poland. If they will ask for some kind of the corridor between Belarusia and Germany. So this is the institution which is not known by Polish law and also international one. Of course, if we will dealing with the territory of Belarus as a territory under, I don't know, civil war, or if they are somehow bad treated because their faith or because their race or because their political opinions. So if they will, for example, join the opposition toward against Mr. Lukashenko, so okay, if they will be then somehow bad treated by the Belarusian state, so yes, they can say that they are refugees, and we have no rights under the Article 33 of the Geneva Convention, if we will treat them as refugees, to push them back. The problem we have in Geneva Convention with this, not the letter of or the exact phrases in the Geneva Convention, but with over-interpretation of the convention, which was in fact the convention not very friendly towards the refugees, because it was made in the 1950s. In 1940s, in fact, prepared in 1951 passed. So it was the time of the very strict and old-fashioned statutory international law, where the sovereignty of state was the basic principle and jus cogens of the international law. So not the present times when we have the international norms made by international institutions and preparing the norms over the norms and reinterpretation of the norms far, far away from the letter of the convention. So this is the first problem. The second one is that we are using the term of hybrid warfare when we are dealing with this crisis, this particular crisis. But again, we are in the blurry part or gray zone of the international law, because there is no definition in the international law, statutory law, of course, the hybrid warfare. The doctrine behind this hybrid warfare and this hybrid war employed by the Russian Federation and today also by Lukashenko regime, it is based by the concept of the Gennady Gerasimov, who was the chief of staff of the Russian army. And it is the doctrine which says that one of the tool from the toolbox of this warfare is using the tools which will allow to disrupt some political order or disrupt social order in the hostile territory, to use many tools which are tools not traditionally connected with the warfare, just to achieve the goals which were up to today reserved by the traditional kinetic. We call it kinetic, but it is traditional war actions, like starting war, giving casus belli, taking the territory, and then under the terms of peace, we are dealing with some concessions from the defeated side. So without war, we're trying to achieve the same or similar goals like during the traditional war. However, the main purpose of this doctrine is to behave at the state of antebellum, before the war. So all these actions has to be prepared this way to avoid the traditional casus belli, so not to allow to connect direct, especially armed forces of the hostile country, to some actions taken in fact under the umbrella or under the financing or under the direct guidance of the security service or state services of the state. So, because the problem of this hybrid warfare is not just modern. We had same situations, especially between the India and Pakistan, when the both sides are sending not just the refugees, but also armed groups, militias, mujahideens to the another side, and even it incited the huge war, the kinetic war between the sides, when the Pakistan sends 100,000 of volunteers through the border of Kashmir. So this kind of the warfare is very well known. However, the regulations and international regulations are very weak. We have only conventions connected with, for example, prohibition of the supplying and employing mercenaries. And this one, if we will prove that that the people are paid by the government of Belarus, we can employ this convention. we are very, very far from anything which can trigger the Article 5 of the NATO or Article 51 of the United Nations Charter, because also the influx of the migrants itself, if it is in another circumstances, if we are speaking about transferring 2,000 migrants from one border to another, has nothing to do with aggression, has nothing to do with endangering state, even small state. And we have to, if in the normal circumstances, not this particular one, we will have nothing to comply, because if we will try to assess what is the impact on the social system of Poland to receive 2,000 new citizens, even if all the people will receive the refugee status. So the impact on our social system or our security, on our economical system, even if we have to feed the people, settle them, if we have to pay them some monthly salaries, will be so minimal that from the point of view of the international law, we will lose in any case under any international law in any court. So why we are afraid? So why we are speaking all the time that it is a hybrid warfare and why we are calling it aggression? Because we are afraid, and it is the main point, that if we will allow this 2,000 persons and we will make this publicly, so we will allow them not illegally go across the border somewhere in the deep forest, but under the Lukashenko's conditions. So we can expect that the next month we will have 100,000 at the same border, and then the potential impact on our security and our well-being and also on our political system will be much deeper than when we are dealing with 2,000. So this is the first part. The second one is that in fact this influx of the migrants has nothing to do with migrants itself. The purpose of the Lukashenko was, and this is the typical hybrid warfare tool from the toolbox, is to show Poland and Lithuania, so the two basic enemies of the Lukashenko's regime, that the Poland and the Lithuania, well, Lithuania not today, but we had the same situation on the Lithuanian border, that they are the countries who are breaking the international law, especially humanitarian one, that they are somehow behave violently against the children and the women, and they are using even chemical weapon against those refugees. So the purpose of this action was just to isolate two countries, to where's the opinion, international opinion, and to disable ability of building any coalition which can endanger the Lukashenko's regime. But unfortunately, all these theses we have, and all this very clearly even declared by the Lukashenko's regime, because he is not ashamed of the action, they have nothing to do with the international law. So our cause is still very weak. But from another point of view, all the European nations, and it is a bit different situation which we which are dealing in the Mediterranean, we have very well defined the state actor, who is and his intentions are very clearly declared by himself. And then we are dealing not with the migration problem and and also the refugees problem. So under the rules of the Geneva Convention, but we are dealing with the aggression, and we are defining it outside the international law, in fact, as an aggression, because unfortunately, the common international law, the statutory law, is from this point of view of defining hybrid warfare, asymmetric conflict, and migration as a pressure or as a tool in such a conflict is very weak. And we cannot expect in the future, in the nearest future, that the nations will be able to agree on some kind of the universal norms which will prohibit it. But still, we have the traditional international law, which said that every country has right to self-defense. Every country is the sovereign state, because the sovereignty of the state is the fundamental part of the international law. Without the sovereignty, we will not have the international law itself. So if you are, and also the Geneva Convention said that nothing in this convention, and many other also regional conventions, said that even the conventions which are dealing with human rights, every single convention said that no inside the conventions is against the principle of the sovereignty of the state. So the state is sovereign when it is able to defend its borders. The state is sovereign when it is the only hegemon, if I could say, which deals with the internal rules and internal laws, which is also responsible for social order and economical order on the soil. So these tools are all the time the option for, even if we are dealing with such kind of the gray zone, which is not directly addressed by the international law. So I think that it is some insights which can be used by you as, or treated by you as fruitful. Okay. Thank you for attention.
Thank you very much for this contribution. Thank you very much for raising many issues that would be very interesting to comment on during our fourth section today during the seminary. And thank you for speaking about the system of sources of international law. Because in fact, yes, we are all aware that the traditional sources theory of international law is evolving on our eyes. Before our eyes, and what we see now is much different from what was codified in the Statute of the International Court of Justice in Article 38. And of course, we see now that what you describe as overinterpretation, we can even say abuse of the convention of the Geneva Convention. With those guarantees being developed by practice, by jurisprudence, without any action of the sovereign states and any consent of the sovereign states, may lead in the end to infringement of the rights of true refugees. And thank you very much for this comment on the self-defense, because if we say that there is no hierarchy of the sources of the law on the international level, there is one tier of hierarchy there, the basic peremptory norms that are above other sources. And among those peremptory norms, there is a right to self-defense. And if we are able to analyze the situation on the border and to define the actions of Lukashenko regime as actions of unlawful intervention, infringements on sovereignty, then we are entitled to invoke self-defense that will be above other obligations and will entitle Poland, Lithuania, Latvia, and other countries of the border of European Union to suspend other obligations in order to provide space for self-defense. I would like to hear opinion on the legal options for Poland, and maybe comment on those issues that we have already covered by Piotr Wymysłowski from the Department of Migrant Rights and National Minorities at the Ombudsman Office. The floor is yours.
Thank you very much. I would like to present the Commissioner for Human Rights, who is also called the Ombudsman, Ombudsman's perspective on the matter. The Commissioner has observed the recent changes in Polish legislature regarding migrants and granting international protection, and he has expressed his views in a series of addresses to the Minister of the Interior and Administration, to the Prime Minister, and to the Senate, which is the upper chamber of the Polish Parliament. 3 acts were recently amended, and the Commissioner has found those new regulations to be potentially in violation with the provisions of at least the Convention relating to the status of refugees, which is the Geneva Convention of July 1951, namely Article 33 of the Convention, which is also enshrined in the Polish Constitution in Article 56. Firstly, let us remember the actual texts of the provisions. Article 33 of the Geneva Convention states that no contracting state shall expel or return a refugee in any manner whatsoever to the frontiers or territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group, or political option. This is repeated in the Polish Constitution as follows. Foreigners shall have a right of asylum in the Republic of Poland in accordance with principles specified by a statute, and foreigners who in the Republic of Poland seek protection from prosecution may be granted the status of a refugee in accordance with international agreements. It is important to remember that whether a migrant can be recognized as a refugee requires a thorough and fair proceeding, and without that we cannot say whether a migrant is or is not a refugee. Regarding the regulations and the recent amendments, firstly, the regulation of the Ministry of the Interior and Administration on temporary suspension or restriction of border traffic at certain border crossing points was amended on 20 August 2021. This act was initially introduced to combat the spread of coronavirus. However, newly added Section 2A states that any person who has crossed the border in violation of the rules and procedures established under this regulation is instructed to immediately leave the territory of Poland. And then the second provision added, Section 2B, states that the persons found on the border crossing of Poland, where border traffic has been suspended, shall be returned to the state borderline. Regarding this regulation, the Commissioner has observed that, apart from doubts as to whether the Minister was even authorized to issue such a regulation because of its scope, the catalogue of the regulation does not include persons seeking international protection. It seems, therefore, that the provisions of the regulation may conflict with the provisions of the Geneva Convention and Polish Constitution. Provisions of this regulation allow forced expulsion by executive order that may also lead to collective expulsion based on a written protocol which merely documents the illegal crossing of the person onto the territory of Poland and thus result in a violation of the prohibition of expulsion. This does not guarantee the fair and thorough procedure in recognizing whether a migrant is indeed a refugee. Secondly, the Foreigners Act was amended. According to its new provisions, those who cross or attempt to cross the border in violation of the law and who are immediately detained should be subjected to an administrative procedure, whereby the commanding officer of the border guard post may issue a decision issued upon crossing the border in violation of the law. That is a rather lengthy title of a decision, but that's how the Act calls it. Such decision obliges the foreigner to leave the territory of Poland and prohibits them from re-entry to Poland and other Schengen states for a period of 6 months up to 4 years. This decision may be appealed to the commander-in-chief of the border guard. However, this complaint does not suspend the execution of the decision, and so the person is expelled regardless of any appeal which they may make against the order. And as we can imagine, appeal from outside of Poland is highly unlikely. Regarding the Foreigners Act, the Commissioner observed that the new provisions do not provide any guarantees that the foreigner against whom steps have been taken to issue the said decision will be able to remain on the territory of Poland until the submitted application for international protection is considered. This means, obviously, that the above-mentioned regulations should be considered contrary to the prohibition of expelling or returning foreigners, the non-refoulement principle resulting directly from the Geneva Convention. The proposed regulations also seem to violate Article 9 of the Directive of the European Parliament of 26 June 2013 on common procedures for granting and withdrawing international protection, that is number 32 2013 directive. According to this directive, applicants for international protection should be allowed to stay in a member state for the purposes of the procedure until the determining authority takes a decision in accordance with the procedures in force, at least at first instance. And finally, the Act on granting protection to foreigners on the territory of the Republic of Poland was amended. The new provision permits the head of the Office of Foreigners, at his or her discretion, to not examine an application for international protection where a foreigner was immediately apprehended after crossing the Polish border in violation of the Schengen Borders Code. This is subject to a provision which seems to mandate the head of the Office of Foreigners to examine protection. To examine a protection claim immediately after the border crossing occurred, only when the person has come directly from territory where his or her life was at risk or at risk of persecution or serious harm, and if he or she has presented credible reasons for illegal entry. Regarding this act, the Commissioner has observed that the same premises can be found in the already mentioned Directive 32. However, they serve a completely other purpose. They allow for a simplified and accelerated procedure for examining applications for international protection, guaranteeing that the applicant will maintain the basic rights of a party to the proceedings. The newly adopted legislature fails to do so, thus being inconsistent with the directive. The Commissioner has underlined that the binding provisions of law do not leave any doubt that any person who wishes to apply for international protection at the border should be, temporarily, for the duration of the proceedings on examining the application, admitted to the territory of Poland, and the officers of the border guard post are obliged to accept an appropriate application. It should also be noted that the above-mentioned provisions do not make it necessary to consider the actual situation of the foreigner in terms of the possible granting of a residence permit for humanitarian reasons or a tolerated stay permit, which again lead to violation of the principle of non-refoulement. Apart from the provisions of the Geneva Convention and the Constitution, Article 19 of the Charter of Fundamental Rights must be remembered, according to which no one may be removed from the territory of a country, expelled or extradited to a country where there is a serious risk of being subjected to the death penalty, torture, or other inhuman or degrading treatment or punishment, and possible automatism in issuing these decisions to leave the territory of the Republic of Poland, and above all, a failure to assess the individual situations of any foreigner, also pose a serious risk of violating the prohibition of collective expulsion of foreigners, laid down in Article 4 of Protocol 4 to the European Convention on Human Rights. Finally, it should be noted that the European Court of Human Rights has found already that Poland has violated inter alia Article 3 of the European Convention on Human Rights, which prohibits torture or inhuman or degrading treatment or punishment. And the court has found, and Poland has done so, by not accepting the applications for international protection from foreigners at the Terespo border crossing. That is the perspective of the Ombudsman. Thank you very much for your attention.
Thank you very much for the Ombudsman's perspective, the perspective of the Commissioner for the Human Rights. I'm not sure if I hear you well. Please just reply if I understand well that any migrant, according to the position of the Commissioner, may apply for asylum anywhere on the border.
That is correct.
Thank you. It would be very interesting to comment on that and to discuss that in the fourth section of today's seminary. And also, this additional perspective will be very valuable to comment on. This additional perspective of those fundamental peremptory norms that allow each of the countries, each of the sovereign states to invoke self-defense that trumps other treaty obligations in this specific perspective of the hybrid warfare. And now we move on to the comments sections of today's seminary. And I'm very grateful to Dr. Bartomy Vroblevsky, member of the Parliament, who is here with us and who will start this comment section with his remarks to the presentations of today's seminary. The floor is yours.
Hello, thank you very much for the invitation to this seminar. I'm really grateful to you to organize it. It is very important problem important, current, and difficult at the same time. The situation on Polish Belarusian border is something very new for public opinion in Poland. It's new for us, but as we heard during the seminar, it's not so new phenomena in the world. Many countries in the past had to struggle with different kinds of hybrid wars. So we might say it is a universal problem, not only a specific one problem who Poland has been facing for the last months. I would not like to express any firm position on this topic because I'm aware how difficult it is, and I can see that there are different opinions in the subject. It is delicate because it is question of human rights. It is important because it causes a lot of fear in the public sphere, particularly in Europe, particularly in Poland this time. But surely we have to rethink our positions concerning migrants, refugees, because we can see that this established international law institutions concerning them are misused, and it is aimly done by, in this case, by President Lukashenko, but generally it is done in different situations. But surely it is not aimed, such measures are not aimed to the good of people who need help. So thank you very much for the invitation, and I hope there will be, after the end of the seminar, Ordo Iuris is going to prepare some kind of summary, maybe with propositions, how to resolve this problem, how we should interpret international law according to concerning migrants and refugees. From one hand, to help people who need to be protected. On the other hand, to exclude possibility to misuse these institutions of protection for the aim to destabilize situation in Europe, in other countries. So thank you very much, and I will be waiting for a written summary of this seminar with the propositions which were showed today, which were presented today, and what I think is very important to enlarge the discussion about this, enlarge in the sense to embrace public opinion and lawyers from other countries. So the first step, maybe not the first, but important step was done today. But at the end, as for international law, we have to have even not common agreement, so broad agreement in Europe, at least in Europe, to really reshape the refugees law, migrants law. Only in this case it might be effective. So thank you very much, and I'm at your disposal in the future for this subject and for other things which are, I think, important for all participants of this meeting.
Thank you very much for your perspective and remarks. And yes, our today's seminar is aimed to present different international perspectives on this issue, and also to work on new solutions that will be able to counter new threats of hybrid warfare and new threats of weapons of mass migration that we face today from Belarus, but our friends from Hungary or Italy faced already years ago from their neighbors. And that's why I would like to ask those questions to our international friends from the Alliance for the Common Good. We have the gray zone hybrid warfare, as Dr. Szewko mentioned, or we have unlawful intervention, as it was described by Weronika Przebierała from Ordo Iuris. And we have aggression even mentioned by European Union commissars. What is that? What are we facing in reality? How should we qualify? How should we define the actions of Belarus on the Polish-Belarusian border? And what is most important from the point of view of the Charter of United Nations, are the actions of procured migration by Lukashenko regime acts of intentional threat to international peace and security? Because if we consider it as an intentional provoked threat to international peace and security, then that grants the Security Council of United Nations power to intervene. I would like to ask Istvan Kovac and then Margherita Saltini for a position on that.
Yeah, thank you very much. I think what we see now, as some other contributors refer to it, is not a new phenomena. I mean, it's new to Europe, but globally speaking, it's not new at all. However, what we are lacking is proper definition and legal framework. So the legal framework, what we try to use to tackle or to manage the current phenomena is so downdated. Uh, and I wouldn't say that updating the current legal pieces would solve the situation, because the European Union tried it several times and they failed. A change of paradigm, a paradigm shift would be required. And in the light of the new paradigm, a new legal framework should be given, since the current approach to the situation where we, of course, from a legal point of view, we can say that there's a difference between a migrant and asylum seeker. But when we are talking about, the European Court of Justice, the UN, and the international bodies who are entitled to judge whether a practice of a country is in line with the international rules or not, they are not really stick themselves to the original spirit of the very treaties, which clearly makes a difference between a migrant, asylum seeker, and the refugee, in the eye of the European Commission, and then the eye of the respective bodies of the UN. Every single migrant is not a possible refugee, but a refugee itself without any qualification. So the current legal framework is ineffective because we here in Europe pay a lot of money to someone who breaks all the rules in the world, make his way to the European Union, illegally enters the border, and then waiting for his case to be decided for years. And each and every month, we Europeans, we pay taxpayers' money a lot, thousands of euros to each person, while um, in the developing countries who are, potential migrants, um, they are forced to live of, 1 to 2 euros per day, a person. So we somehow consider breaking the rules to be more profitable. And we reward actually those who breaks the laws, and we do not reward those who stay in their countries and try to make a better life. So the current situation is not good for the countries they are fleeing off. I mean the economic migrants, uh, because those who manage to make their way, through the whole globe, and it's not an easy way. It's a dangerous way, and this is why, the most capable and competent part of the habitants, like young males, the one who managed to make it through. But these are those who have the potential to have a better life in their country of origin. So, like the country of origin, letting them flee to chase a false dream in Europe, it's not good for the migrants, it's not good for the countries of origin, and it's not good for Europe. So, first of all, I think we should change our approach and reward those who act in line with the current laws and stay in their countries and help them. And this is what Hungary does. There's a Hungarian program called Hungary Helps, and in order to help these communities, Hungary put a lot of money. I mean, of course, with a Hungarian scale, speaking a lot. So from a European perspective, we could do a lot to help these communities. And maybe, just maybe, if we would, allocate the money, even the small portion of the money we allocate for those who stays here illegally, and should have been expelled to their country of origin. And we should use this money to have the communities in their domestic countries who act in line with this law, one thing. And another thing is that the effective legal framework provides or provides only rights for the asylum seekers, no obligation at all. So just we heard that according to the position of the Polish ombudsman, any migrant, any applicant can file his application anytime, anywhere at the border. So this is not, in line with the current situation. So imagine, like we Hungarians, we build a border fence. And I know that Poland will do the same, like many countries did before. So how in the world would it possible that, they showed up at some point at the fence, and from the other side of the fence, which is literally another country, they will file an application or what? So I think the Hungarian legal framework, which provides the opportunity to file application, but only in the transit zones. This is a very good way to act in line with the spirit of the treaties and to really help those who are in need, but to not let anyone who will not qualify for asylum, for sure. And once you let them to enter your country, it is really hard to expel them, more because they will not stay in Poland, nor in Hungary, nor in Italy. They will move towards the central of Europe, and hence the European Union, came up with many solutions during the years, but all of them based on the same idea to reallocate or resettle those who are already were in Germany or the Benelux countries and in the center of the European Union, to allocate them to those countries who are not the targets of these migrants. So the European Union, the current leadership of the European Union, with the effective legal framework, will not solve the situation. And this is why I cannot emphasize more that this is the competence and obligation of every state to manage its border, to defend its border if necessary. And just really one last point, that at all, what is the purpose of every state? What does sovereignty serve? It serves to protect a certain territory with a certain population. And this is the purpose, the obligation of every state. And if a state fails to do so, it is, well, not self-evident anymore that it qualifies as a state.
Thank you very much. Thank you very much for this plea for new paradigm on the issue of migrants and refugees. And yes, we have to agree that there is a need not only to declare the protection of borders true mean for supporting refugees. In fact, on the end of the process, and at the same time, we need new instruments on the European level of support, of humanitarian support and help to the countries of origin. That's what Hungary does. That's what Caritas Poland does with cooperation with the Polish government in Syria and other countries. And as we heard, Margherita Saltini mentioned that Italy was declared as violating international migrant and refugee obligation by cooperating with Libyan forces on the Mediterranean Sea. What is your opinion on this situation? Is it possible to invoke the self-defense principle that trumps over other treaties if it is invoked in order to provide security to the borders and then to support migrants in the countries of origin? Or if you would like to comment on any other issue mentioned today, please, the floor is yours.
No, I think it's very correct, because if you look at the Italian example, we have the before and after of a very important issue, a very near neighboring country, which is Libya. Libya had a shifting political situation that is still deteriorating in the course of the year, and is still what we're facing now as a problem. Because at the beginning of the migrant crisis in the past, it started many years ago. It didn't start in 2015. It had actually started before, and there was an agreement dealt with the regime that was in Libya back then, which was the Gaddafi regime, and that was possible because it was not an enemy in that case. It was a country that had started negotiations, that had historical alliances and ties with Italy. So Italy had made an agreement that is very similar to the ones that later on was made by the European Union, led by Germany, with Turkey. So basically they were saying we were cooperating mostly on financial, economic, and organizational level to keep migrants in Libya and not arrive illegally in the European Union and in Italy. And it worked. But then civil war started in Libya. There will be new elections soon. But in the last years, it has been better. It has been improved, the situation. But there were chaotic years where Libya became the departed country for lots of migrants. And what is very dangerous, and has been addressed in Belarus as well, is that right now there are 2,000 people coming mainly from Iraq. They're not that many, and they're from Iraq. So the real potential refugees. But this can change. It can change extremely quickly. Migrants from countries that have nothing to do with Belarus, nothing to do with Poland, that are very far away, and nothing to do with refugee status as well, can potentially come and cross the borders in Poland. In the moment you open a window, the air comes in, everything. It can be windy, can be sunny, can be warm, it can be cold, but anything can in. In the moment you create a porous, open border, you get infiltration, and you cannot control them if it's done illegally. You cannot control the nationalities. You cannot control the wave, and you cannot control Belarus. That's the main problem. As Italy could not control Libya for a very long time, Italy, the European Union, we could not make efficient deal because it was not working, because it was a country dealing with civil wars and internal problems that were massive. So there was not an actual control of sovereignty inside the state. We cannot produce deals with Belarus right now because it's not a country we trust. It's not a country that believes in human rights right now. It cannot be enforced, a deal with Belarus. So in the moment we accept the current situation, we create an open border. And to Belarus, anything can go in. The third nationality of migrants arriving to Italy now, today, are from Bangladesh. Imagine the trip. Is it a neighboring country to Libya? No. So not even, we don't even, sub-Saharan are very few coming to Italy, for instance. So you would think in the past they were crossing the Sahara Desert, getting to Libya, and then getting the boats, paying human traffickers, and arriving to Italy legally. That's not the case anymore. The third nationality is Bangladeshi people, who are a lot, by the way. They're 12% of the people coming. So at the same moment, all this Bangladeshi population that wants to migrate to Europe and the EU illegally, they could go through Poland. They take 2-3 flights, and they arrive in Belarus, and they try to cross. And that takes, there's organizations, human traffickers organizations are very organized. They are very powerful. It's a great business. It's a business that also affects, and that's very worrying, it also finances, in some cases, terrorism organizations. And it's a criminal thing that we have to fight. So I would like to preach and thank Poland for being so firm and to getting the European supporting it, because we see that the country in front of it cannot, there's a binding level, or we cannot treat and make a deal properly with Belarus. And that's very important. And it's actually a luck. It's a big luck, not only for Poland, but for the rest of the European Union. And in that sense, I would like to thank also the opening of Mr. Vroblevsky, that said that it's important to enlarge discussions on it. So I think that from today on, if you will need some help in conveying lawmakers and politicians from other realities, including Italy, I am available to help on that. Thank you.
Thank you very much for your contribution and for your remarks. And yes, we all need internationalization of this process of protection of the borders. We all need this possibility of support of whole European Union. And that is why I mentioned Bogusław Liberacki from Socialists and Democrats, because this shows up that something has changed in the political architecture of the political forces in Europe. If all the forces in the European Parliament were united in protection of the borders of the European Union, and that is something totally different from what you have experienced as Hungarians and Italians during the past years. And yes, we hope that it will be a long-lasting change in the policy of European Union. And Dr. Szewko, I have one question, especially for you in this comments section, because you mentioned this over-interpretation of convention before, and at the same time you mentioned that the convention was very strict on refugees when it was drafted. On the other hand, we hear what is the official position of the Commissioner of Human Rights in Poland, that is very in line with the position of some of the international human rights organizations as well, that we should accept applications from the migrants anywhere on the border, not only on the border passes. And this is also a problem raised by Istvan Kovac from Center for Fundamental Rights. If we build a wall, then where those applications should be filed? And that is what I have raised in September this year during one of the seminaries, academic seminaries, the issue that if we very, very strongly focus on accepting migrants anywhere on the board, then the wall will be built because it is impossible. It's impossible for the border guards to be able to be everywhere on the border. So, what is your position on this single statement from the commissioner?
So, I think that I have the impression that such a position is, of course, somehow supported by even quotation of the convention. However, this is also the second part of this Article 33, which said that the sentence of this Article 33, where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group, or political opinion. We don't know his political opinion, and we don't know his race, religion, or nationality when he is trying to cross illegally border. So what stipulates the Ombudsman and also the Human Rights Commissioner, that the state should immediately resign from the main principle of the statehood, which is the sovereignty of the state, which is, as I think, the jus cogens, something which is, sorry, someone is calling. I think that you're technician. Perhaps, do you hear me properly or not?
Please continue.
Do you hear me?
Yes,
sorry.
Yes, please continue. I hear you very well.
Okay, so perfect. So we have to resign from our sovereignty, and the principle of this sovereignty, as is, which is use cognizance of international law. We have to resign from the idea of the border of the state, because this position, if we will agree, stipulates that every single person has the right to cross the border in any place. So all these ideas of the border, of the custom control, of the passports, are in fact illegal, because we have to allow any person who has such a fancy time just to cross the border. We have to allow it. And then we have to, on our soil, discuss with such a person what is the status of the person. And of course, we have to also agree to this person to start all this legal procedure to have the refugee status or not. But if this person will receive the refusal of this status, and we will expel such a person according to our law, so the next day the same person can also again go through the border, because the border is not existing anymore. So if we have such a theoretical situation that 2 divisions of the Russian army, together with tanks, we go through the border, so we should allow them, and then ask them, are there the refugees or not? And are they here to ask us for the international protection, perhaps on the human rights ground or the humanitarian ground? So we are going to some kind of the absurdity when we are following only the part of the international law, and we are not dealing with all the system. Even if we are dealing inside the country, when the card, I'm sorry, I'm not a lawyer, I'm a specialist of international relations, but I remember Professor Bieżanek, who taught us that even if we have a court of law inside the country, so if there is if the court has to deal with some complex matter, so it cannot avoid to include in the deliberation also the basic rights like constitution, even if we have some direct disposition inside inside the Bill of Rights. And so we cannot avoid such a discussion and say, okay, so the European Convention of Human Rights or even the Geneva Convention is acting outside of the whole system of the international law, and especially the basic principles. Because if we will follow it, so we can allow any absurdity. So why we are dealing with the passport control on the borders or on the airports? Why we are requiring the sanitarian issues? So if I am crossing tomorrow the border of Czech Republic, for example, without the COVID document, so they can stop me, arrest me, they let me to go away, but I will say, okay, but I'm dealing today with my migration mood, so I would like to migrate, and perhaps I will applicate for the refugee status. So they have to cancel all their regulations just to allow me to act because I like to. So this is I'm sorry that I'm showing some kind of some ridiculous and absurdity of this kind of thinking. And if we are dealing with Russia and Belarus, I will not be surprised if they will do such a theater using their military, for example. What shall we do this way? We have 2,000 soldiers of the Belarusia Spetsnaz, which they crossed the border and said, okay, you cannot stop us, okay, and we will go to the camp. You will show us, and we will wait then and we will issue the application for international protection. Thank you.
Thank you very much. And you said about absurdity of the situation, but we have experienced the hybrid aggression of Russian Federation against Ukraine. And if we consider that those were military who were crossing the borders of Ukraine without any military uniform, so this absurdity is more and more possible in relations between Poland and Belarus, because we can imagine that among those people on the border there could be as well many members of the military. It is absolutely believable that it is so. Of course, we need a voice from Piotr Wymysłowski, a stance from Piotr Wymysłowski from the Department of Migrant Rights and National Minorities of the Commission on Human Rights, because at least two issues were raised in connection with your statement before. The first one about the self-defense priority in the system of international law, and what is the position of the ombudsman on that, or your personal position on that. And the second one was, of course, the position of the remark of Dr. Szewko about this absurdity, as he says, of over-interpretation of the Geneva Convention. Please, the floor is yours if you want to comment on that. We can't hear you now. No, we can't hear you now. Please try to reconnect if it is possible. I will ask. Oh yes, do we have any connection? Please try to reconnect. I will ask Istvan Kovac for his remark, as he already asked for a voice now.
Yeah, I just wanted to thank Dr. Szewko to draw the attention to the absurdity of the situation, and I join his remarks from all of my heart. And if I want to summarize what is the problem in one sentence, the problem is that the effective legal framework provided by the European Union, not really the Convention of Geneva itself, but the pieces of law issued by the European Union, provides more right to the migrants, to any applicants, than to European citizens. So just as Dr. Szewko said, if I want to cross a border of a country, I should, obtain like permission if it's needed. And if it's a European country and we are talking about Schengen area, still, I should have my document with me. I should cross the border via a designated point. And we seem to forget these rules when talking about any migrant. So not just, refugees. And of course, there are respective cases when, we cannot accept someone who is definitely fled for his life to have documents with him or her. But, crossing the border, any point, a green border, without the intention of, connecting the authorities, it is unacceptable, and it leads nowhere.
Thank you very much. Do we have connection with Piotr Wymysłowski from the Ombudsman Office?
I'm here. Hello.
We can hear you very well. Please.
Oh, great. Thank you very much. Yes, the answer to the second question, I think it's pretty simple, and I would like to answer to that, since the Geneva Convention, the Article 33, has two sections, and the second section of this article states that the benefit of the first provision, which states the non-refoulement principle, the benefit of this provision may not be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he is, or who, having been convinced by a final judgment of a particularly serious crime, constitute a danger to the community of that country. So I think that pretty much answers it. But I really do not believe that that was the case in Usnash, for example. And I want to invoke this example, since that would also answer the first question. The commissioner has observed, as stated in his letter to the Prime Minister from August, I think it was 20 August 2021, that he has seen the border guards performing their duties on the migrants on the border near Usnash. And the migrants, on the other hand, stated in English loudly and clearly that they wish to seek international protection in Poland. I think we've all seen those migrants. They were families with children and women and men as well. It is therefore the commissioner's belief that the migrants were within the jurisdiction of Polish border guards, who were obliged to process the migrants' requests accordingly. And to be clear, this does not conflict with the right to protect the country's border. Poland can, and in fact it should, protect its borders. However, when a migrant who wishes to apply for international protection enters Polish jurisdiction, we do not have any other legal option than to process this application until, that is, if we speak of the current legal situation. That is the commissioner's view on the matter.
Thank you very much. And especially for the second issue, I had this opportunity to discuss this issue twice with Ombudsman, as it comes to the jurisdiction of the Polish border guards. And of course, we all know the position of the commissioner. But to my opinion, to the opinion of Ordo Iuris, the jurisdiction may not be broadened to the territory of the neighboring country only due to the voice being heard by the border patrol, because it will of course lead to building walls everywhere, because as we know, walls don't have ears. So the jurisdiction will be then limited. But of course, this was just on the side notes of this discussion. Thank you very much. Thank you very much for this position. Would you like to present your final remarks? Thank you very much. Thank you very much. Our time is 15 minutes above the limit we have set preliminarily. Thank you very much for the discussion today. Thank you very much for this international perspective, and thank you very much for this interdisciplinary perspective that we were able to present today during the seminary of the Alliance for the Common Good. It is very important to speak about the issues of the border crisis, of the migrant crisis, not only from the strict legal positive perspective, but also from the broad perspective of the international public law, and above all, from the very broad perspective of interdisciplinary analysis of the basic functions of the state, with the security of the citizens and the security of the state as the basic and fundamental function of the sovereign states, even in the modern era. Thank you very much, and thank you. And I would like to express my gratitude to all the participants in the on my left, Istvan Kovacs from the Hungarian Center for Fundamental Rights, Weronika Przebierała from Ordo Iuris, Margherita Saltini from Nazione Futura from Italy, Dr. Wojciech Szewko from National Center for Strategic Studies, Piotr Wymysłowski from the Department of Migrant Rights and National Minorities at the Office of Commissioner of the Human Rights, and Dr. Bartomy, Vroblevsky, Member of the Parliament. Thank you very much for the seminary, and I hope we'll meet again to discuss this issue in more detail. Thank you very much.